Cynthia over here. The House Elections Committee will come to order. Would the clerk please take the attendance?
Chair Tsernoglou.
Here.
Representatives Wagella.
Here.
Pope.
Here.
Kolazar.
Here.
Burns.
Here.
Churches.
Present.
Smith.
Present.
DeBoyer. Here. Madam Chair, you have a quorum.
Thank you, Mr. Clerk. Representative Smith makes a motion to adopt the minutes from the March 12, 2024 meeting. Without objections, the minutes are adopted. All right. Now, I just wanted to read off a card. We have a card from Sherry Ritchie from Pure Integrity Michigan Elections, Michigan Fair Elections, Stand Up Michigan, the Freedom Alliance, Mid-Michigan Women for Conservative Values. She is opposed to HB 5550 and HB 5551. All right, I believe we have a few proposed amendments and substitutes to discuss before voting on HB 5550 and 5551. Representative DeBoyer makes a motion to adopt the following amendment to HB 5551. Representative DeBoyer, would you like to speak to your amendment? Yes.
Just basically what my amendment does is it gets the legislation more in line with the provision provided in the Constitution with regard to elected officials. There's a 20-year prohibition for certain criminal activity that may have been perpetrated by an individual to be eligible to run for office, to hold office. And I think that there's definitely some inconsistency with regard to a lifetime ban on the ability to be, for the lack of a larger description, a poll worker, let's say. But yet an individual could be the county clerk, the township clerk, the governor for that matter, after a period of time and a number of years. And, ironically enough, I was able to watch criminal justice testimony this morning, and I would hope that at minimum, these people would be eligible for the second look legislation that's being entertained by members of this body as well. So it's a fairness thing to me. That's how I see it. So I appreciate it, Chair.
Thank you, Representative DeBoyer. Mr. Clerk, please call the vote.
On the motion to adopt the amendment, Chair Tsernoglou.
No.
Representatives Wagella.
No.
Pope.
No.
Kolazar.
No.
Burns.
No.
Churches.
No.
Smith.
Yes.
DeBoyer.
Yes.
Madam Chair, you have 2 yeas, 6 nays, 0 pass. The amendment is not adopted.
Thank you, Mr. Clerk. Representative Smith makes a motion to adopt substitute H2 to HB 5551. Representative Smith, would you like to speak to the amendment?
Yes, thank you, Madam Chair. I just would like to offer up a substitute that provides a little bit more clarity and all around, not just for election-related offenses, but violent crimes as well. So the intent of this amendment is to add additional groups of crime that would exclude somebody from serving on the state or county board of canvassers by banning any convicted of a violent crime or a felony involving accepting or giving or offering to give any bribe, the embezzlement of public money, extortion, or the theft of public money, perjury, or conspiracy to commit any of those crimes. Furthermore, we define violent crime with an extensive list of crimes, ranging from murder, rape, child abuse, child porn, as such. So we would like to have that added as well.
Thank you, Representative Smith. I do wish to note that we are working with the bill sponsor, Representative Arbit, on a list of crimes and clarification on that, as we do need to take a closer look at the crimes. So I am not in spirit opposed to some of the crimes that you listed there. However, we have not had the needed time to discuss with other stakeholders the specific list of crimes. So I will be voting no today, but look forward to working further as this bill continues to go through the process. Mr. Clerk, will you please call the vote?
On the motion to adopt the substitute, Chair Tsernoglou.
No.
Representatives Wagella.
No.
Pope.
No.
Kolazar.
Pass.
Burns.
No.
Churches.
Pass.
Smith.
Yes.
DeBoyer.
Yes.
Madam Chair, you have 2 yeas, 4 nays, and 2 pass. The substitute is not adopted.
Thank you, Mr. Clerk. Representative Wagella makes a motion to report HB 5550 with recommendation. Mr. Clerk, please call the vote.
On the motion to report, Chair Cernoglu?
Yes.
Representatives Wagella?
Yes.
Hope?
Yes.
Colazar?
Yes.
Burns?
Yes.
Churches?
Yes.
Smith?
No.
DeBoyer?
No.
Madam Chair, you have 6 yeas, 2 nays, 0 pass. HB 5550 is reported with recommendation.
Thank you, Mr. Clerk. Representative Hope makes a motion to report HB 5551 with recommendation. Mr. Clerk, please call the vote.
On the motion to report, Chair Cernoglu?
Yes.
Representatives Wagella?
Yes.
Hope?
Yes.
Colazar?
Yes.
Burns?
Yes.
Churches?
Yes.
Smith?
No.
DeBoyer?
No.
Madam Chair, you have 6 yeas, 2 nays, 0 pass. HB 5551 is reported with recommendation.
Thank you, Mr. Clerk. Now, we will have a presentation from the Michigan Board of State Canvassers. If I'm not mistaken, we have all 4 board members here in attendance. We have Chair Mary Ellen Gerwitz, Vice Chair Richard Hauskamp, and Jeanette Bradshaw, as well as Anthony Daunt. Can all 4 of you join us at the podium? Welcome and thank you for joining us today. The board is here to discuss some formal recommendations that they have requested of the legislature, while also outlining how they landed on these recommendations and why they are hoping to see these things done by the legislature. I'm hoping that this presentation can be very informative to all of us as we start this process of considering the recommendations. So welcome. We'd love to hear from each of you and your role on the State Board of Canvassers and then the presentation.
Well, thank you for giving us the opportunity to be here today. This is a subject that we have dealt with over the course of the last year, and probably everyone will recall that in 2022, we were faced with nominating petitions, the Bureau, which acts to canvass petitions before they come before the obligation to canvass formally comes before the board. The Bureau was faced with nominating petitions that had huge numbers of forgeries. And the Bureau and the board had to deal with the question of how to canvass. We have an obligation under the statute to canvass, and we need, under the various statutory commands, to determine whether there are a sufficient number of valid signatures and whether whether it's an initiative petition or a nominating petition, to determine whether the petition complies with the form requirements that are set forth in the statute. But when we looked at this, we realized that there was really no specific statutory direction with regard to what it means to canvass. And we have discussed with the board and with practitioners what our practice has been, how we might want to change it, and what we need to see or think would be helpful for us to have in the statute. The Bureau, about, I think last February or March, came to the board with a recommendation that the board, when canvassing nominating petitions, use random sampling. That is, looking at a number of the petitions and determining, and so as to determine whether that random sample indicates that there are a sufficient number of valid signatures. Random sampling has been used to canvass initiative petitions for constitutional amendments, for initiated laws, and also for referenda, all of which are constitutional rights of the voters. So random sampling is a procedure, a practice, which the Bureau has used for decades, but it is not in the statute, and it appeared to us that it ought to be in the statute, and also that the statute should be clearer on some of the things that we need to consider. And specifically, you will note that in the recommendations that the board has made to this committee, we are suggesting that the use of random sampling be specifically incorporated into the statute, both for canvassing nominating petitions, for canvassing petitions for a new political party, and for canvassing petitions, initiative and referendum petitions. We have also, and let me add that the board discussed this on a number of occasions, and Vice Chair Hauskamp and I then met in a working group with practitioners who had been presenting on both sides to the board over the course of many years. That was particularly informative. We reviewed with the practitioners, both in the working group and also at meetings of the board, what they wanted to see, what would be helpful for them as well as for us. And I think that will continue we will continue those discussions about procedures which don't need to be incorporated into the statute. But with regard to the incorporation of changes in the statute, as I said, what we have concluded unanimously is that it is important to have the random sampling process statutorily required.
Can I just confirm something with you on that? I believe what you said is that it's already being used currently by the Bureau. Now, is it already being used for all forms of petitions?
It's being used for initiative petitions,
Okay.
but not for
Nominating petition. Okay, I just wanted to clarify. Thank you.
Right. We did, I don't want to take up all our time, but we did have one set of nominating petitions which the board had rejected because of the forgeries and other defects. We had random sampling done on that petition, and what it revealed was interesting. That is, that the random sample had even more defective petitions than had been determined with a less without random sampling. There's one other thing that we have addressed, and that is we have recommended, although that we have some questions, but we would like the committee to consider amending the statute to change the standard by which we determine whether there is sufficient compliance with the form. For years, substantial compliance was essentially the standard that was used to evaluate petitions. In 2012, in a Supreme Court decision, the court said that it was that we needed to ensure that petition forms strictly complied with the statute. And the statute at that time would say that a petition shall be in 14-point type, shall be, a particular size, shall contain a particular warning. So the standard strict compliance has been in effect for a little more than a decade. It does give both practitioners and members of the board a much, as I said, it's strict compliance. It tells you it has to be this way or we reject it. But that has proved to be a difficult standard to enforce, sometimes requiring the rejection of petitions that comply in all but immaterial aspects. So that is one that we think requires greater consideration. And I would add that the practitioners, for the most part, Republican and Democratic, ones who have both opposed and supported petitions, really urged the rejection of the strict compliance and the amendment of the statute, which would essentially reject the Supreme Court decision or overrule the Supreme Court decision. They urged that we adopt a substantial compliance standard rather than strict compliance. So let me now.
Can I just ask you, since you first touched on random sampling, explain what, if not random sampling, what the procedure is for nominating signatures versus random sampling currently?
Right. That would probably be something that would be better addressed by somebody from the Bureau who engages in that
Sure.
for us.
No problem.
I can
Yeah.
address that to a degree too.
Just so that we fully understand what that change would be.
So, I have to leave at 11, so I'll speak for 6 minutes straight and then get out of here.
Sounds good.
On the random sampling issue, if you recall in 2022, there was all of the fraud, and it was a big issue at the time. And the Bureau essentially engaged in what became a random sampling process because they had so much work to do and so many signatures to review. And when we got the recommendation on the Board of Canvassers to reject certain candidates because their signatures were determined to be fraudulent, despite believing the recommendation and the work and having faith in the work that Jonathan and Adam and the rest of the team did, I voted against that recommendation. I did not want to kick these candidates off the ballot because there wasn't a process in place to do random sampling. The court ultimately decided that what they did was acceptable, and at the time it was Norm Schinkel and myself decide, what the court says, we're going to vote. And so that was part of the genesis of this issue, is give them the ability and the tools to do random sampling for these larger 15,000 signature candidates, because it is a lot to look into, and it works well for initiative petitions. Why shouldn't we have that process for these? And so if this had been in place in 22, I think we could have avoided that step of going to the court and having a deadlock on those candidates, because there would have been something in statute, in process, that allowed us to reject those candidates on that basis.
Thank you. Were you going to speak further to some other things, or since you're leaving?
Simply, I think what is before you on these issues of random sampling, I think is a common sense piece that should be adopted. It makes it easier for staff to look into this and provide us a recommendation, and it does so in a scientifically scientifically valid way that was explained to us and laid out to us by experts, and we have faith in that process. And the other piece I just wanted to state was, as a Republican on this board, it's rare in election law and in elections in general to have Republicans and Democrats agreeing on things. And I've sued Jocelyn Benson in the past before I was on this board. I have been a thorn in the side of the Bureau of Elections when I was with the group called the Michigan Freedom Fund, and I'm proud of that. But this role is important, and it's important that we have faith for our elections process. And I think that what they've put forward is a sensible piece of legislation. And the last piece is on the strict versus substantial. You have an instance where a Republican and a Democrat are more in favor of the substantial, and a Republican and a Democrat are more in favor of the strict. I'll let Jeanette speak to that when the time comes, but ultimately, I appreciate the opportunity to speak to this panel about this, and I think the Bureau, the staff in particular, does a nice job of keeping us up to date and has explained the reasoning behind this to the point that I'm comfortable with what they've laid out. So.
Thank you.
Thanks for having us here this morning.
Welcome.
I guess, you know, I would touch more on the substantial strict, and I'm the junior member here. These folks have been here forever. I'm the newcomer. True.
Can you just in case anyone isn't sure who's who, can you?
Oh, I'm sorry. My name is Richard Hauskamp.
Okay, wonderful.
I joined in about almost 2 years ago. So I think, as was mentioned before, Chair Gurwitz and I were part of a working group that we put together with practitioners to discuss a couple things. One was the random sampling, and the second was the strict versus substantial. In my time on the board, I've seen petitions for candidates, petitions for referendums brought in front of us where the strict standard, I think, has created an enormous injustice, more for candidates than initiatives. I think, I'm almost certain every one of you has an experience in collecting signatures. That's how you got here, right? You know, probably the most profound I've seen that the strict created an injustice in the election system was a pastor from Detroit who had gotten enough signatures to get on the ballot last campaign. Unfortunately, some of the sheets he'd copied on the church copier, and it took off the copyright and it took off the printer's mark on the bottom of the page. And so he was rejected. The strict compliance has led to a lot of things here that I don't think were intended in the original law. And so with substantial compliance, it allows a little more latitude. It allows a little more common sense. It allows a little more looking at what's being presented to us. And so, and that was also, by the way, the feelings of the practitioners. In terms of the random sampling, that's a huge opportunity for you folks. And I'm coming at it from totally non-political here. Random sampling is the first steps toward a technological change in how elections are counted and how petitions are processed. It gives Michigan the first step toward really enhancing processes to make them more automatic, to make them more streamlined in the future. The reality is that with social media, with where we are as a culture, you're going to have more petitions, not less. You're going to have more initiatives, not less. And so the ability to do the random sampling is a way to start stepping into to using technology as a way to vet. And today it's in things like the forms, and it's in things like random sampling, the signatures. But a few years from now, it'll be 99.9% accurate, right down to the signature match in the voter file. So this is a good place for Michigan to be a leader.
Okay, hopefully you can hear me, but I have a pretty loud voice, so we can go from there. I'm Jeanette Bradshaw. I am the longest member appointed. I was appointed in 2013, so I have been here for over a decade, so bless you. I kind of you had a question about random sampling, but what was done before. On those nominating petitions, they would do a face value evaluation. So each page, well, first they would come in, and then they would be counted. And then from there, each of those pages would be evaluated page by page by page. So to Member Hauskamp and Member Daunt talking about process and time, if you have a candidate that has to submit 30,000, I believe is our threshold, is it 15? I just want to make sure. I'm looking at Adam because I don't want to. 15 to 30,000, put that by 10, maybe 12 signatures per page. And so each page has to be evaluated by the Bureau staff for every single person who runs for those offices. So when we're looking at the fact that we have technology that's already been in place for initiation legislation, referendum, and constitution, why can't we use that for a nominating petition as well? Now, I've been on the board long enough that it took a while, and I will be honest, because I look at it as this can go through, and like, how do we miss those little minutiae that we would see on a face value? The statistics show that they actually can be even more thorough, because once, what we could do is, I believe that we increase the number of the number of signatures. I want to make sure I keep on looking at them because I know it, but originally right now in initiation legislation, they would only draw a 500 signatures out of all the signatures that were there. And now what we would do is, I believe it's 1,000 for a statewide drive. So that's 1,000 signatures. So they put it into a computer system that would randomize how many, like which of the numbers. So I don't mean to get too technical, but this is what happens. So they would say on petition number 7, we're going to use signature line 5. So as soon as you pull that for the random sample process, now that entire page has to be reviewed. Not just that line, but if the circulator at that point, if the circulator signed before the rest of them, if it's torn, if there are elements of the form that are missing, that page is already taken out along with that sample signature. Correct? Adam, yes, okay. I've been there for a while, so I'm going on how long I've been here. So my recommendation, being there longest, having been through a number of random sampled petitions that have come before us, I mean, we've had them come in where they only have so many signatures, but I feel that's a good move for us, and I think I respect and I absolutely agree with Member Hauskamp. We want to be on the forefront of technology, and the technology is going to be there for us to move. So if we put that random sampling in place, I think we're going to be really in a good place for us here. But I wanted to talk about that strict versus substantial compliance. And Member Daunt kind of hinted on that. Now, Member Daunt and I have been on the board longer than our fellow board members. And while I understand, and I completely understand the argument that it is, it causes, as someone told me once, it just disenfranchises people to run for office. I'm also one that if you can't follow the rules to run for office, then I might question whether or not you're the individual I want in office. But on that though, like, I honestly, I want to have the conversation. And we've had the conversation on the board. I understand where the practitioners really want to, because they're practitioners, they're lawyers. And they have that innate, like, the problem, I think the term was the gotcha moment. Like, oh, we have this petition, oh, gotcha, it's right here, it's the form problem. But my concern is, while that can happen, and I've said this at meetings, so this is nothing new for, if our meetings are all broadcast, if anyone wants to watch them or be in person. But my concern is the current iteration of the board, and since I've been on since 2013, we have worked together, we listen to each other, and we go through that. But that may not be the case as we move forward. And my concern, I just want to voice that. My concern is that if the board decides that there could be an issue and play the partisan game on the board and eventually having something deadlock because it's substantial and it doesn't meet this form. So I am in favor of the legislation and the recommendations. I just hope that we have that kind of conversation about compliance, strict compliance, and substantial compliance.
So just to be clear, the board as a whole is recommending substantial compliance? Okay.
I just
Okay. Just want to make sure I understand.
I said it in public. I've said it publicly in one of our meetings. I just want to make sure, and I know that Member Daunt and I are about. There's places. One of the candidates that we removed in 2022, and it was there were 3 of them. There were 3 candidates I can remember, and they were congressional candidates. One of them basically came in front of us and said, I have the worst penmanship. And so what they did is they had typed out, printed, cut out of paper, which I don't know why they didn't use the PDF, but they cut out all of their information, then they taped it on the petition. And unfortunately, when they did that, they completely removed the name, the district, all of the required information that's required on the form in an attempt to solve their penmanship issue. That's heartbreaking, because someone actually did a time, they circulate all their petitions, but to have their form not be correct. The other one was a judicial candidate who accidentally, as Member Hauskamp had said about a congressional candidate, when they copied their petition, they had left off just like the edge of a letter in a required element of the form. So as heartbreaking as that is, strict compliance allowed us to say, I'm really sorry. And that's where I can have the conversation about it, but that's why I wanted to at least address and have the conversation and be very,
Sure. Can I ask, I'm not sure, are you also going to be addressing some of the other recommendations, like the changing of the filing deadline, the obviously fraudulent piece, and as well as, I think we've got something regarding removing congressional district or county? Are we going to?
That is a change that is necessitated because the statute still contains language that says that petitions will be circulated by congressional district. And that was because of a statute passed in 2018, PA 608, which was held to be unconstitutional. So the language is still in the statute, but there's a footnote under the statutory language, which says this part of it is unconstitutional. So it's really just cleaning it up.
So this is just to codify the fact that it's
Changing the
unconstitutional.
filing
Okay.
deadline is something that is partly required by changes in the law. Obviously, there have been so many election law changes over the last 4 years, 5 years really, and you have dealt obviously and very well, I think, with the changes that were required by the 2022 ballot initiative. But the changes that we are recommending with regard to earlier filing deadlines will allow the board and the Bureau to do the job that it needs to do. It also allows the practitioners, and that's one thing that I think we didn't discuss with regard to random sampling of initiative petitions. There is a process by which people can challenge petitions. And with regard to nominating petitions, the Bureau has, for the most part, relied on challengers to examine the petitions more carefully than the Bureau is capable of doing. And so the detailed examination of the validity of signatures is something that the Bureau simply cannot do, but it is done occasionally, if the resources are there, by somebody who is challenging a nominating petition. If random sampling is undertaken and approved, actually I think that we have already said we think that we have the authority to do it, but we want the statutory confirmation. But that will mean that the Bureau and the board are not relying upon the public or challengers to identify fraudulent signatures or other problems in the petitions. It will allow the Bureau and the board to do the work that they really need to be doing.
So if we do have the random sampling codified and used for all signatures, would we still need to? Do you still see a need for changing the filing deadline? And if so, why is that?
Let me ask Mr. Fracassi to identify that, or to speak to that.
Sure.
So the idea with coming from, that came out of the work group and that's come out from the board meetings with adjusting the filing deadline was largely to give more time for the process. With the signature minimums are set by statute for candidate petitions, but they are based on total turnout for the gubernatorial race for statewide drives. So as higher turnout has occurred, it's resulted in higher signatures needing to be submitted, a minimum number, but then those cushions that are submitted are even more. So for example, in 2022, in the 2022 cycle, so calendar year 21 and calendar year 22, we had 7 statewide drives filed. We received easily over 3 million signatures. 2 drives alone had 1.6 million signatures submitted to us. Those have to be canvassed in in 60 days. It's a very tight window, and so it doesn't allow for a lot of time for challengers, for example, to be able to review. It's a very tight turnaround. What we saw as well, in addition to the work group recommending changes to the filing deadline as well, was in 22, a couple of justices in a couple of different litigation that was filed against the Board of State Canvassers on decisions made. I think at least 2 justices of the Michigan Supreme Court recommended additional time to provide for greater review for the Supreme Court and for just greater review. Oftentimes with candidate or ballot question filings, court cases are filed and decided in a weekend, just because it's the timing. After the board certifies or makes a decision on the petition, the board then has to draft, the Director of Elections drafts with board approval ballot language, and that has to be done 60 days before the election, because the Secretary of State is obligated to call the election and provide the ballot language to county clerks and city and township clerks for ballot programming and ballot preparations for the election itself. So the request and the discussion about extending that filing deadline came to just allow for a little bit more space for all of those pieces to happen.
Can I just take that a little conversation a little bit further? So, as I understand it, you get 180 days to collect petition signatures before they become expired. I'm not sure if that's the right term. And where is that? I assume that's codified statutorily. I don't know offhand.
471 or 472 in election law. It's one. I believe it's one of those.
And is that something that you would consider increasing if we were to increase the amount, if we were to push back the filing deadline? Or is there like a specific reason for those?
So I will defer on that. I'll start first with just kind of saying how the 180 days works now. That did not come up in the work group, so I don't want to step on toes. But how the 180 days works now is we just look back 180 days from filing. You can start petition drive whenever. When it's filed with the Bureau of Elections, we just say, okay, so you filed today, 180 days back from there is where all of your signatures need to be gathered. So that's how, so it's based on that side. It's not based on a starting, but based on a filing position. As far as whether or not that should be amended or not, I will defer.
I guess I bring that up just in terms of concerns with kind of the timeline and how that would alter the current timeline. I know that a lot of petition gathering takes place in the warmer months. Notably June, there's a lot of festivals, there's a lot of outdoor activity where, and I'm not sure if this is subjective or you can actually tell by the petitions that are turned in, but at least subjectively, we have a lot of strong believers that most of the signatures are collected in those warmer months, getting closer up to the election, and that if those months were lost, that it would be significantly more difficult to obtain the needed signatures. So I'm just kind of trying to think through how we could, accommodate your timeline, give you the amount of time you need, but also provide the amount of time that our petition gatherers would need to get those signatures.
Certainly, there is a signature gathering season, and everyone recognizes that it isn't in the dead of winter, although we have had a pretty live winter. So there may be efforts undertaken right now, but as Adam explained, you do go 180 days back, and so the petition sponsors, they calculate when they need to start. And they can, and when they need to turn in. So we're suggesting that the petitions would need to be turned in earlier, but they can adjust when they want to do it. That is the latest date for them to file a petition, but they can certainly file it earlier and start collecting signatures at an earlier date, which is more convenient for the efficient collection of signatures.
Can I ask a question? Madam Chair, could I ask you a question?
Sure.
When you suggest longer than a 180-day window, do you have a number in mind?
Not necessarily. I'm just kind of asking if you're open to that, because when I go through, and these dates might not be exact in my head, but when I go through the deadlines, it sounds like if someone was running right up until your deadline, which groups frequently do, just according to human nature, that's kind of how we do things. That would put the collections starting around Thanksgiving, maybe around November, and then. But if we were extending the amount of time that was allowed, maybe the fall would somehow be included in that signature gathering time frame.
To, for example, the county fair period, about mid-July to.
Yeah, I mean, I'm just kind of thinking that through. If there's any specific reason why. I mean, obviously, we don't want signatures that are too old being included, but if we're allowing people to collect signatures and file them, much before that deadline anyway, they would still be. They still would have been collected, much sooner. They just wouldn't have had as long of a time range to collect them. So I'm just curious if there's any specific reason why it would have to be limited to that number of days, or if we could look at potentially allowing for more days to collect the signatures if we are going to require them to be submitted, at that earlier time period where essentially they wouldn't be able to take advantage of those warmer months before the election. So, there may very well be a good reason not to do that, but I'm just asking if you know of one.
It is not something that we have considered, and that was not part of our working group or of the Bureau's recommendation. Personally, I think it's a good idea. I have represented ballot question committees, and I can say that I'm sure they would appreciate having a longer period of time to collect signatures. 180 days, particularly given Michigan weather, is not really the best period, and it is just part of the statute for whatever reason, and perhaps not for a good reason. I would like to just add something about the substantial compliance,
Sure.
About experience that the issue arose, and in the case where there was a challenge to whether or not the heading of a petition was in 14-point type. The statute requires that it be in 14-point type. the Supreme Court spent a great deal of time looking at what point means, what type means, what font means. There was actually, in this case, expert testimony about whether it was or was not in 14-point type, which, when you think about it, is ridiculous. The point is that one needs a heading which is sufficiently large for everyone to see what it is that they're signing. So to get into that kind of effort, the gotcha effort to say, you're wrong here, about something so minuscule as that was just kind of absurd. But that is what strict compliance has required. And I would just bring up a case that I had.
Can I ask you to just pause for one moment? I apologize. We have a couple members that need to leave, and I want to offer them an opportunity to ask questions, and then we're going to continue with all of this. But I believe Representative Wigala would like to ask a question before he has to leave.
Yeah, and sorry, this is not directly related to what we were just talking about, but I mean, it kind of is. But I just was curious, and here it talks about allowing the Board of Canvassers to disqualify obviously fraudulent signatures. Can you talk about like what would make something obviously fraudulent? Like, how do you determine? How do you make that determination, I suppose?
I want Mr. Fracassi to deal with that because he was the person who was most in charge, most challenged by the requirement that those petitions in 2022 be examined, and actually did come up with a lot of instances of what tells you that a signature is obviously fraudulent. And that was included in a report that was presented to the board, and also in a report that was examined by the courts, which considered challenges to the determination that several candidates should not be on the ballot. And I think the court was impressed with the determination and with the way in which the Bureau identified obviously fraudulent signatures.
So in general, the Bureau's role, I want to make sure I'm explaining it correctly. Our role is to make recommendations to the Board of State Canvassers. So in doing that, what I would say is the first instance one of the instances that we saw in general with 2022 of something that may be obviously fraudulent was where the circulator has signed the entire sheet themselves. And you can see that because the penman, you can tell the penmanship. And to be clear, when we're looking at signatures themselves, we're not, we are very lenient to voters. We take into consideration that voters are signing on a clipboard in whether all of those factors. So it has to be something that is just night and day different. Is kind of what we're looking at here. So the first instance I would say that something that's obviously fraudulent is when you can tell by looking down that sheet that one person has signed that entire sheet. And another example would be what's called roundtabling. It's similar where there's the set number of penmanship, but they would pass it around a table, for example. So I'd be assigned line 1, Richard would be line 2, Mary Ellen would be line 3, Jeanette would be line 4, and then you just repeat. I'm 5, 6, 7, 8, so on and so forth. You can see those patterns, for example. In 2022, another example that we saw was there was a high number of people who were no longer registered to vote that quote unquote signed petitions, and they had been canceled because they were marked as deceased. And they were marked as deceased 5 years ago. So that's another thing that the Bureau would recommend to the board. Importantly, in that instance, it's referred to the Attorney General. The board is not an investigative body. What we're looking at this to say the signature does not match or the person's not registered to vote. Is there something else going on here potentially? Then we need to refer it to go through the investigative process to all of that.
Did you have any other questions? No? Okay. Okay, thank you. I apologize, Ms. Gerwitz, for interrupting you. I just wanted to
No,
make
I
sure we
just
got that
wanna-
question answered, but you may continue. And again, I'm sorry
Thank you.
for interrupting.
I wanted to cite another example of a case where the strict versus substantial compliance arose. It was with a judicial candidate who went appropriately to his county clerk to get nominating petitions. And she gave him the petitions, which he used and circulated and got us a sufficient number of signatures. And the Bureau of Elections recommended not certifying his candidacy because he had used forms which had been replaced by a subsequent form. The clerk didn't know it. She received from the Bureau of Elections forms. She did not realize that they made the forms which she already had out of date, nor did the candidate. He relied upon the clerk. And the Bureau recommended that candidacy not be certified. I think a couple of you were clerks, and you know how traumatic it was. The clerk testified how horrified she was by what had happened. And the board of canvassers in that instance said, we cannot reject the candidacy for this reason. But I cite that because it shows what happens when you are applying a standard which in many instances just doesn't make any sense and is unfair.
As the only member who kind of has a little bit of a different, is it okay? I'm sorry.
Excuse me. Oh, yeah. Just want to note that apparently there's some issues with hearing some of the people who are a little bit farther from the microphone. So I don't know
Try as
if we
much as I
can
can over here.
extend or something.
Yeah, and unfortunately, like, I'll start over. Actually, I was on the board for that last one. And that's where it kind of, I appreciate the ability to be able to make those choices. And so that is why I voted to support. I needed to kind of clarify that though, because it's substantial, the strict compliance makes it easier for the board to say, this isn't right. But there are cases that we should have that leniency to say, it's not the candidate's fault, and it's really not the clerk's fault. I mean, really, it's what happened. But we should be able to have that kind of leniency, but there are items that are required. And so the conversation, I know at that meeting when we talked about it, is that there needs to be that flexibility of, if we have that issue, if it is oh, I'm really sorry, but that T looks like a uncompleted F, but it really is a T. Want to be able to have the board have that kind of consideration, but also not open the floodgate of, oh, I don't have to follow any of these rules. And that's where I'm at. And it makes it easier, yes, strict compliance, but we should also have the flexibility to say, you know what, you have really horrible penmanship, we understand, we are going to accept this petition. So that's where that's why I said yes to allow to go to substantial. But I also felt that the conversation needs to be had, the legislature too, and for us, so.
Sure. I think we have a few more questions here. Actually, I have one myself, and then Representative DeBoyer has a question. This is just not on something that you spoke on, but just wanted to also clarify this. It was also my understanding that there was a request to have An individual who is paid to be a signature gatherer must sign a sworn affidavit stating that they are a paid signature gatherer before gathering signatures. Otherwise, those signatures are invalid and must not be counted. To have that removed statutorily because it was ruled unconstitutional. Is this also correct, that this is one of the requests from the Board of, okay. I just wanted to make sure we were getting that correctly. And then I believe Representative DeBoyer has a question.
Thank you, Chair. First, thank you guys for what you do. You know, although I may not agree with everything in these provisions, from the years that I did it, and I mean it sincerely, I appreciate what you do. It's a very thankless job, probably for the best description, as the Bureau knows that, right? And Jeanette, interestingly, I mean, I'm residing where you are on that with the compliance, and that form issue was a hang-up, right? We reviewed petitions as well, and it was this form hang-up. And what we saw time and time in court cases was that the judge generally would always, except for that one, a local judge, a circuit judge, would rule on behalf of the candidate / the electorate, right? And they would always want to err on the side of the candidate and the electorate. So when that ruling came down, it was like it was inconsistent with what I would have been able to previously argue how a judge would rule when we would be reviewing petitions. My concern is that, similar to yours, Jeanette, is that if we're going to go to substantial compliance, would we at least try to spell out what you go from being ministerial in your duties to actually a deliberative body at that moment, right? Because you're going to look at, you could be divided, right? So are we going to attempt to at least spell out the idea that what you're considering is legitimately just the form, not open to interpretation on other required qualifying provisions? Because that would be my fear. And I would love to hear your opinion if that's kind of, we're on the same page on that logic to a degree. That's one question. The second one would be on the sampling. I don't know if I'm there on the sampling. However, would there be an appeals process put in place that says, if you use sampling and you reject me, do I have the ability to appeal that sampling determination?
That has not arisen, and random sampling has been used, as I said, for initiative petitions for decades, because it's simply not possible. What happens, though, with the random samples, there is a lot of participation by the petition sponsor. So the sample is provided. As Jeanette explained, it says, okay, petition number 5, signature 4. That's part of the sample. That is provided both to the petition sponsor and to anyone who might be challenging. And so they have the opportunity to look at all of the sampled signatures. And if there is a determination that those signatures, that some of those signatures are not valid, and there will be, some of them are not going to be valid, then the sponsor has the opportunity to rebut and to say that really is a valid signature. So there's a lot of participation in the process, in the random sampling process, and the ability of the sponsor to dispute the determination about invalidity. But there has not, there was a Sixth Circuit case some decades ago which accepted the idea that random sampling was undertaken, but there has not been a challenge to the process, to the use of the process itself. It has simply been accepted.
But to play to your question, inherently you're suggesting something that could be built in down the road, and that would be the same as if you and I were doing something that involved statistical sampling here.
Right.
If you disagreed with the results of a sample, it's easy to resample.
Sure.
It would be easy to have someone who is a challenger come in and say, okay, we want to draw 5,000 more names or 5,000 different names. And mathematically, the results should be the same for both.
Right. Yeah, I'm not saying that I have the solution. I'm saying that that's
No, but
the
that's a
discussion
good-
that
that's
needs
a
to be
good point,
had.
though.
You're right on the money. The discussion needs to be had.
I think in the process, right, I mean, the current random process on petitions, initiation, legislation, referendums, and constitutional, that, you know, what you're saying is appealing the decision of the board to, but I think that's making the assumption that the individual didn't participate in the challenge.
Sure.
And so, having been on the board for a number of years, there have been in the reports about signatures that have been challenged, but that have been put back in with communication with the Bureau. And so we, you know, one of the petitions that came in front of us when I first got on the board in 2013 was raise the wage. They came to the board on the report with 36 signatures, basically out of that 500 petition to the good. And what I mean that by the good is they have 36 signatures over in that range that would say you certify or you don't certify. We only got about 36. The challengers to the signatures came in and submitted, I believe it was like another 62 signatures. So that would eliminate that 32 that they had above the threshold to certify. And once those were brought into the conversation and approved by the board, the challenges were, now that group has 36 signatures short, which brought them under the threshold to certify.
Right.
And unfortunately for me, or however that was, I mean, I was on the board for maybe, I think, not even 3 or 4 months. I voted with the staff recommendation, which was not to certify that raised a wage petition, because the challenge in that process, that challenge had taken those 36 signatures and now made them deficit 36 signatures.
Right, because the provisions for certification on signatures it's a threshold. It's either over the number and you stop, or to a number that it's certain you're not going to get the maximum, right? So so you're just kind of taking that just to a little greater degree with using the scientific random sample to prove it, and prove it again if necessary, right?
It's been a scientifically validated sample for many decades. But what the Bureau did, and it was very helpful for us, was to commission a report, and there was an examination of the sampling process and a recommendation to change it in certain ways. And we had that was from a company, Raman. And we then had that report reviewed by an academic. So we were confident that the recommendation for changes in the methodology of random sampling were going to be beneficial to us and, you know, would give us confidence. And it is at a confidence level, which is what sampling is. Like, you're 95% certain that the sample is giving you accurate information.
Well, thank you guys again. I appreciate it. Thank you, Chair.
Absolutely. I don't know if Mr. Fracassia has anything to add to that, because I know from what I've seen is that, you know, it's almost never just, you know, one party, you know, submitting and then no one. It's always a legal process. It's always other parties challenging, and there's really a lot of back and forth, you know, on those signatures to determine whether or not they're actually valid or not. So I don't really have a fear that, you know, something might happen like that, but maybe you can address that.
Yeah, I can just kind of further expand a little bit on the process as well, and I hope that I can speak loud enough to be heard. It's not, the microphone doesn't seem to want to stay this way. But just the other piece that I would add as well. So the process in general, like has been explained, when we pull the sample, we make it available to anybody that asks for it. It's available to the sponsors as well. We always encourage the sponsors to pull the sample so you can see exactly what we're working off of, same with challengers. And we will do all of the work and gather information from the sponsors, challengers, anybody that's participating in the process. And we use that to develop our staff report. Our staff report has to be published 3 full business days before the board meeting, and that's when we're just making the recommendation to the board. So kind of to your point about the appeal process. At that point, that's when anybody can come before the board and say, this is what we want to have happen. We want X, Y, and Z, or we think that something wasn't done right, whatever the arguments may be. The board has, before, they have said, we want you to go back and look at this as well. And from there, if there is still the further appellate process from there is you actually appeal directly to the Michigan Supreme Court as well in any decision related to initiative petitions that the Board of State Canvassers makes. So that was just the only other point I wanted to raise to your question.
I don't know if we have any more questions, or you had more to add.
I would just like to add that we are really blessed to have Vice Chair Hauskamp on the board because he's the tech guy. He understands what I don't, but he is quite determined to push us in a direction where whatever technology is available to us, AI, which maybe everybody is afraid of these days, but AI would certainly be beneficial, we think, in helping us to evaluate the validity of signatures and perhaps the compliance with form requirements. So we are determined to move in the right direction. We have urged the board to look at what other states are doing and to see if there is technology which is available. So the recommendation that we have made with regard to random sampling is that the statutory language that we've recommended is that the board is authorized to use random sampling. But we don't want to be locked in, so if some other kind of technology became available, we would hope that we could take advantage of that.
Can I ask just one quick question before kind of concluding? So you know how county is still something that has to be on the signature on the sheets for the signature collecting. Is that something that that you feel is still very much needed? Is that part of the process? Okay, so that's because we've had that question come up from various individuals.
So I think, there's 2 different types. Primarily, there's 2 different types, the city township form and then the county-wide form. The city township form is needed for certain things. It's easier to use a city township form, especially for like a proposal or something like that to amend a city charter, for example, or something like that. That can be easier. So that's just one example. But when we're talking about a statewide drive or a statewide candidate or something like that, city township forms can be difficult, both from the Bureau to process, but also for the sponsors of the petitions to be able to gather signatures. It resulted in a higher number of errors on behalf of voters using a a post office city versus the actual registration city. So that was, it's picking up Siri, I think, instead of city. That was originally prior to PA 608. Statewide drives are allowed to circulate on a countywide form. That remains in the law as well for certain offices and for ballot questions. And even at the local level, they're allowed to as well. So essentially, everybody's allowed, I shouldn't say everybody, but at the state level, they're allowed to use both. We recommend the countywide because it's for a variety of reasons.
But there is a need to have it broken down by county rather than not at all.
Oh, I'm sorry, I misunderstood your question. So I think that was actually something that came up. So if you're talking about a statewide, that came up in the work group as potential to explore. The county-wide itself comes from an older provisions pre-QVF that basically where when we would get filings, we would send it to the locals. The locals were then responsible for looking up at the MasterCard to compare, and we needed to know where to send it to. We needed to know that this was the Lansing in Ingham County versus the Lansing in another county, for example. I think there could be benefits in doing a statewide, but I think that you may need to just do the clearer. The discussion that came up was that you would need to do a clearer, like, if this, then this. I think it may result in further errors if it was like a local issue using a statewide form that may actually result in more errors for that local ballot question at like that city township level. But at a petition that's being presented to the board, the discussion was that could be helpful as like for a statewide candidate or ballot question. But I don't think that was part of it.
No, it wasn't part of your recommendations. I was just curious if that was discussed. Thank you.
think for any particular reason, one way or the other.
I think that the petition form itself could be simpler. There could be many changes made. We didn't address all of those issues. Our particular focus was on the sampling and the standard by which we judge compliance. So, maybe we'll take up other issues. Maybe we'll come to you again.
Well, thank you. This has been really informative. I don't think anybody has any more questions, so I don't know if you guys wanted to leave us with anything in closing, but...
I mean, I've been on this board for 11 years, and I just want to say it's the first time we've actually been, we've come before the legislature when changes have been made about petitions or anything. But I just want to make one point on the fraudulent signatures, and it's the availability for us to refer those signatures that are fraudulent to the Attorney General's office. That in statute would help us at that point, that we can refer those, because we're not an investigatory body. Mm-hmm. We have an investigatory body in the state. And so having us be able to refer those instances to the Attorney General and allow the Attorney General to do what they should be doing in that position, I think that is the biggest one for us.
Although we actually did make that referral, and we understand that
Yeah.
criminal prosecutions are underway, so that I think the statutory changes is that we would be required to make that referral.
But there's an additional piece that you should take into account as well, I think. One of the observations is that gathering signatures has become an enormously profitable industry, and on all levels. I don't have to share stories. You've seen all those stories. As that becomes more profitable, and as the technology becomes better to automate the gatherer side of this, increasingly the state and increasingly our board is going to be in a situation where we have to evaluate really clever people. Mm-hmm. And I think that as you're looking at our recommendations, please keep that in mind too, that's only going to get more intense in the next few cycles.
Absolutely.
And that's totally bipartisan.
Right. Well, I really appreciate that you all were able to join us today, and I hope we can definitely continue on these conversations. And definitely, move forward and continue discussing your requests and how we can best implement most of them or all of them, based on how the conversation continues to develop, as well as considering other changes in the process. So again, thank you, and it's really, I think, beneficial for us to have a bipartisan board presenting for us, on this topic. So thank you all, and we'll continue to be in touch with all of this. So.
Thank you very
Thank you.
much. Thank you. And we appreciate what you do as well.
Thank you. There being no further business before the committee will stand adjourned.